This is
Okay.
SJC-13170 in the matter of an impounded case.
Okay, Attorney Jellison.
Good morning, Chief Justice Budd and Associate Justices, and may it please the court. Eva Jellison on behalf of the appellant. Too often in Black communities and communities of color, police officers fill in the gap between hunch and reasonable suspicion with implicit bias, meaning that they see danger in the typical and common behaviors of Black teenagers when they wouldn't see that danger if the teenager were white. Here today, I'm asking this court to reaffirm its reasonable suspicion jurisprudence. The facts in this case have never been enough. First, I'm encouraging you to continue your careful evaluation of common human behavior that does not reliably indicate criminal activity. Second, I'm asking you to continue to give little weight to the understandable reactions of people, and in particular Black people, to police officers. And third, I'm asking you to factor in the location of the stop and criminal activity in that location only when it bears direct connection to the defendant at issue. Turning to the facts here, they fall short in comparison to previous cases. Here, the juvenile walked away from police officers, engaged in an episode where she looked over her left shoulder at those police officers while adjusting her waistband. And then a bit later, she also walked away from an area where more police officers were present. If we go ahead and compare that to cases pre and post Warren, we see that that simply isn't enough.
Counsel, I don't mean to interrupt you, but aren't you also asking us to disregard what we said we would not do in Jones-Pennell? Because the motion judge credited facts, and from those facts made inferences that are not clearly erroneous. So in order to do what you're asking us to do, aren't we disregarding the facts that were found and credited by the motion judge?
No, Your Honor. So I specifically asked for two facts to be found clearly erroneous. One of them, the adjustment of the waistband, I don't think matters very much. I think that whether or not she adjusted her waistband, we reached the same result. So I'll rest on my brief on that. But as to the other issue, the blading, the judge made a clearly erroneous fact for really two reasons. One, the officer clearly testified that what he meant by blading was looking over the left shoulder. And I mean, I can just quote this. What he said was, as she's walking, she turns to her left side, looking back and forth at the officers several times, back and forth while she's walking before the left turn. That was at transcript 58. So that's what he means by blading. And that's also
Counsel, can I ask you a question? Does the fact that blading only entered into it when the defense attorney brought it up in cross-examination bear on any of this?
I don't believe so, because this is a factual finding. So, the officer was testifying as to what he observed. Blading is an unhelpful loaded term, as Justice Lowy's observed several times.
Yeah, right. And all I'm saying is that that was not introduced by the prosecution. It was introduced by the defense attorney. So how do we factor that? Do we just disregard that then?
Yeah, I think.
What do we do with that?
The fact that it was introduced by the defense attorney, I don't think matters. And I think it would matter more maybe if he just responded, yes, we didn't have any other information. But where Officer Lope specifically testified as to what he meant, and this court is looking at the facts, what happened, and then doing a de novo legal analysis, I don't see where it matters that defense counsel brought that word up first. We look at what happened and we look at if that's enough to equal reasonable suspicion. But I did want to return to Justice Wendlandt. Did you have a question?
I just, because there was a demonstration during the testimony of Officer Lopes, what do we do with that? Because we obviously don't have a visual review of that. So what do we do with that in terms of the Jones-Pennell standard?
In terms of the Jones-Pennell standard, so I would say that you can still, even with Jones-Pennell,
the deference that we owe to the findings of the motion judge in light of the fact that we can't re-see whatever he or she saw.
Right, absolutely. And I think that Justice Wendlandt, that goes more to the adjustment of the waistband. And as I said, I really don't think it matters if she adjusted her waistband, which is common, or moved her hand near her waist, which is common. So I'll start with that. But you can look at the entire facts that were presented to the judge and decide if there was a clearly erroneous fact. And going back to Jones-Pennell, the judge explicitly credited what Officer Lopes said and did. So where Officer Lopes said adjustment, perhaps that was shorthand. He then got up and demonstrated a reaching toward his waistband area, looking back over his shoulder. And I'll say the prosecutor summarized that, but at transcript 28, the court then says, yes, I imagine that means that she summarized it correctly. But also looking back, looking into cross-examination at 55, the defense counsel asked, all you did was saw her from behind making a hand movement on her waist. Yes. So I think that the totality of those facts would suggest that she made a hand movement near her waist. Now, if there's a reasonable inference that she also adjusted her waistband, like I said, I'm fine with that. I don't think that changes the analysis in this case. But I would like to go back to the blading that Justice George was talking about, because I do think it's important. And I just would ask the court to consider what happened here. And I think that Officer Lopes described very clearly what happened here, and that the term blading confused the analysis a bit, but I think we know what happened. From 60 feet away, he sees this girl looking over her left shoulder, and while she's doing that, she's adjusting her waistband. And, you know, if you want to call that blading, that's what Officer Lopes called it, and that's fine. But, you know, I don't think that there's really a consistent definition of blading as you look through the case law. I think we should go with what the officer said he saw, and that term is just unhelpful in this case. And it certainly wasn't a separate behavior. He was describing one episode of behavior. He then said that, yes, that was also, that can be called blading. And, you know, to me, it seems that he thinks blading means turning. So that's how I would address that. So I think it's clearly erroneous to say that she both looked over her shoulder, her left shoulder, while adjusting her waistband, and that she did something else that we would call blading. So I would just ask you to look at the episode of conduct that we have here.
Would you say that the finding would have been more accurate if the judge, number one, left out the word blading, didn't talk about that, but two, had said, if the police officer had testified instead, it appeared to me based on that movement that she was adjusting her waist, because she does say he did say he didn't see it exactly when he testified.
Right, he was behind.
He was behind, and the judge. So should the judge have just rephrased? If the judge rephrased the finding to say, is that really what it's coming down to? Not that she was adjusting her waistband, but it looked like she was adjusting her waistband.
Yeah, so with respect to the waistband, yes. With respect to the blading, I think he could have adjusted the finding to say she was looking back and forth over her shoulder and adjusting the waistband, which Officer Lopes termed blading. I think that would have been a consistent finding of fact with the record. And the second part about blading is that, you know, the judge, the motion judge also found that she was blading so as to conceal something. And Officer Lopes never said that. You know, he said that she's turning to her left side, essentially opening her body up back toward the officers that she's walking away from. So there's no fact consistent with any concealing. And I think that that's why blading was an unhelpful term, because there was no
fact, but isn't that a reasonable inference from the fact that that there was something going on around the waistband? I guess is what I'm getting at, is what level where do you put that compartmentally? Is that a finding of fact, or is that a reasonable inference? Because if it's a reasonable inference, why is that clearly erroneous in light of the totality of the circumstances?
Sorry, I don't think it is a reasonable inference. She's looking back over her shoulder, adjusting her waistband. There was no testimony that she was hiding her side. That's typically what happens here. The officer defines blading as hiding her side. And in this case, he said she's looking over her shoulder back and forth while adjusting her waistband. So I would just ask the court to focus on what happened here, and that finding of two separate things and concealing was clearly erroneous, and that there was no reasonable inference that she was concealing anything. So that's what I would ask the court to do.
You want us to discount the grabbing of the waistband, but we have that testimony. We have DePisa, and I understand that DePisa, there was probably more favorable facts for the government, but we also have the testimony of the police officer that is consistent with the firearm, as the ATF training has, you know, with possession of an unholstered firearm.
So in this court's case, Mata at footnote 8, I think is very, very helpful on this point. So at footnote 8, this court said,
I can finish my question before you answer.
I'm so sorry, Justice Gaziano. Please continue.
It's probably gonna be the same answer. It'll be fabulous, but let me just finish the question.
Please do.
Thank you. So what do we do with the, when you preface your arguments, you said, the police are basically filling in gaps with implicit bias. Here we have this ATF training. Do you want us to throw that out, or what do we do with that?
No, I actually want you to do exactly what you asked the police to do in footnote 8 in MATA. So said we note ordinarily when an officer relies on his training and experience to draw an inference or conclusion about an observation, the officer must explain the specific training and experience and how it correlates with the observations made. And moving further, this is a long footnote, but it's very helpful. Here, the officer did not testify specifically that in his training and experience, the adjustment of one's waistband in the way described indicates that the person may be carrying a firearm. And we have the same thing here. If you look at transcript 16.
I thought that the evidence was thinner in MATA as far as it was just a training experience conclusory statement, and I may be wrong. I'm sure the chief probably knows, but he wrote MATA. But here we have testimony, at least a reference to the ATF training and what came out of it.
Right. But I think that you still need to make a connection to the behavior. So Officer Lopes testified, if you're carrying an illegal on your waistband, you're touching it with your hands, pulling it up and pulling to the side. And if he had gone ahead and testified, I saw her pulling something up and pulling something to the side, we'd have a different case. But he testifies that she adjusted the waistband. So he's not connecting that, in the same way, or he's not connecting that directly as I think that this footnote suggests that he should. And also, this behavior, in MATA specifically, the court held that the defendant's adjustment of his waistband alone does not create reasonable suspicion for a seizure because that behavior is too common. In DePisa, we have something that's a little bit more idiosyncratic. I think, it's less common for someone to be walking with a free arm swinging and another arm pressed against their body. That seems more indicative of firearm possession to me, and at least less common, whereas this is something, more in the realm of something that people do. People adjust their clothing as they're walking.
Right. Let me ask you just one more question, if you would. Okay. So here we have the 3 hour long, 3 hours ago, we have a tip, an anonymous person. The kids are out there. Someone has a gun. It certainly wouldn't justify in and of itself a reasonable suspicion. But can the police use that as a factor in any way? Like we've said, you can kind of use high crime area, you can kind of use walking away, you can kind of use things, but they don't in and of themselves justify. I would to take the 3 hour old tip and just completely put it aside, or where does that weigh into our analysis?
I would ask that the court completely put it aside. So the Commonwealth concedes that the 3 hour, at least 3 hour ago tip really only connects the fact that there were firearms incidences in the area.
Right.
So, and in Evelyn, I think, that's what we had. In Evelyn, there was a police report. It had several incident numbers about things that were going on in the area. There wasn't very much detail about that. There also wasn't very much detail about this. If you look at some of the Commonwealth's appendix, this is an incredibly large area. Officer Lopes connected the firearm incidences specifically to the laundry room. My client wasn't, he didn't testify that she's walking away from the laundry room. There was no direct connection between her and this activity. And in Evelyn, this court held that there needed to be a direct connection with the defendant. And, there's a different situation in that case where there was a recent fatal shooting 13 minutes ago, half mile away. So put that aside, but a direct connection with my client. And you didn't have that. Even if you look at the tip itself, which was too vague to really indicate anything, I think if you look at Menaeus, it really was too vague. But even if you look at it, she didn't fit that description. She wasn't among.
Well, I'm not suggesting in the least that tip would have satisfied anything.
Right. I guess I'm saying that would be a direct connection between the activity being described and her if she were within maybe a group of children in the complex, but she wasn't. So there's no direct connection here.
So your position is put it aside, it doesn't factor in whatsoever.
As in Evelyn, put it aside, it doesn't factor in whatsoever.
Okay.
I see that my time is running down. So I guess, I really do. I think DePisa is a great case for me. I think MATA is a good case for me. And each of those, and Evelyn, there were far more indications of firearm activities. So, Officer Lopes sees something that gives him a hunch that she has this firearm, and he continues to investigate. He follows her and he sees nothing else. In these other cases, the officers approached the person, there was another indication of firearm activity. That happens in Mata. They call out to the person. There's another indication of firearm activity, like in DePisa, a heavy pocket. The most significant detail for this court was that after they saw this idiosyncratic straight arm walk, they also see a heavy pocket. So this court has never said that these factors alone, these details alone in combination would equal reasonable suspicion, and they are simply too common, even in combination. If you have a person walking away from police officers in their neighborhood, adjusting their pants, this simply cannot be enough for a police officer to then grab them.
Does it matter that the judge says it's continuous adjustments of the waistband? It's not just, one lifting up of the pants, right? Does that matter?
I don't believe so, Your Honor. And if you'll allow, I'll get into the facts just a little bit. He sees her doing this, and that's why I call it an episode of behavior. He sees her adjusting her waistband and looking over her shoulder from 60 feet away. After observing that, he then gets out of his cruiser and starts to follow her, and he sees no more behavior. So if it was continuous for an amount of time between when he's observing it from 60 feet away and getting out of the cruiser, and that's continuous, then that seems accurate to me, but it's still, I don't think it changes the analysis.
Any other questions? Thank you.
Thank you.
Attorney Sherman.
Good morning, and may it please the court, Kathryn Sherman on behalf of the Commonwealth. In this case, as the juvenile erratically moved through the apartment complex courtyard, she was observed continuously and conspicuously adjusting her waistband, looking over her shoulder, and turning her body to ensure her isolation. All of these characteristics were witnessed by the testifying officer, a trained, experienced officer, and to him, these behaviors were individualized, specific, and articulable facts that indicated she was illegally carrying a firearm.
Now, counsel, can I ask you a question about carrying the firearm? And that is, you're relying on the fact that are you relying on the waistband to show the illegality of the possession of the firearm? Because simply possessing a firearm legally wouldn't be a problem, correct?
That is correct.
And you can't tell her age from just looking at her, can you? To know she's a minor who shouldn't have it.
The officer does not testify to recognizing her age. However, he does testify to his experience working with young people in the community. So I don't think it's an unreasonable inference to assume that he had an idea of her age. But most importantly, in his testimony, he does draw a very sharp distinction between the way in which typically legal holstered firearms are carried and the way that illegal firearms are typically carried. And he specifically references it being held in a waistband and the way that different secure checks are done to guns being carried in a waistband so that it doesn't drop. And what he describes when giving his training and his background and his personal experience with holstered and unholstered weapons coincides precisely with what he sees this juvenile doing to her waistband.
Can I follow up on a question that Justice Gaziano asked Attorney Jellison about the 3-hour-old tip and the fact that the tip was vague and didn't relate directly to the defendant? How much weight, if any, should this be given to the analysis?
I think it should be given very little weight, and it holds very little import in finding reasonable suspicion here. I believe that tip just falls into the general category of, or the general consideration that would be given typical high crime area consideration. I mean, I feel
counsel,
the testimony
if that's
here.
accurate, let me just follow up on that. If that's accurate, then could not the police consider the crime statistics in the city in general, or just that nationwide there's an increase in gun violence? Why should that have any weight at all? Why is that not like general statistics in gun violence?
In this case, the testimony is much more specific than general gun violence, and it's truly more specific than a general high crime area used in that
But
term.
it's old, it's stale. No, we don't know who it's from. There's no indicia of reliability. No, nothing. How does this even get to be considered at all?
I think it's relevant, and frankly, the Commonwealth's position is that it need not be considered at all, but it's only relevant insofar as the court would consider the shots fired the night before relevant, or the shots fired in the days leading up to it. It's really just the awareness and the situational context the officer is bringing to his reporting to that apartment complex that day.
This case really turns on the ATF opinion. Is there a danger in that we basically say anything pursuant to this ATF training equals reasonable suspicion?
His ATF training, the 2 trainings that he did with the ATF, are only one part of what he describes as his training and experience with firearms. He describes those 2 courses, or he explains that he's taken those 2 courses. He then gives personal information about carrying a firearm, his personal experience with that, the difference between a holstered and unholstered weapon. I think he blends that with his training. And he also explains his experience recovering firearms during arrests off of people's body. He says that he's made 40 gun arrests, 20 of which the guns were taken off people's, I believe he says off the person. So his specific background training and experience goes beyond the ATF
Counsel,
training.
in order to give that last point any credence, don't we have to know what the denominator is? That is, how many patent frisks were failures?
Here, there is no evidence of that in the record.
Right. So given that we don't know that, how do we know that the 40 resulting in firearms isn't like a 1% situation as opposed to, I don't know, at least half, something, or 30%?
I'd argue that that isn't necessarily anything the court needs to find. That would
Well,
be.
isn't it important to know how often Officer Lopes is right in order for us to assess whether the 40 arrests is relevant?
It's a challenging question to answer because I understand your point that there is no known denominator. However, the judge during the motion was in a position to ask follow-up questions about that point if he thought that that was of import to his finding of facts and the reasonable inferences to draw therefrom. And he did not, and he credited the testimony in full. So I do recognize that it was not overly specific, not overly detailed. It's just one of many factors explaining the lens through which he saw these behaviors.
Counsel, can I ask you about another factor?
Yes.
The first factor, as I read the transcript, seemed to be that these 2 individuals, including the defendant, broke off from another group. And it was interesting because as you read through the transcript, initially Officer Lopes tries to testify to what he thought was in their minds when they saw the approaching 6 or 7 officers, and an objection was interposed that was sustained. But then he was able to testify to his observations about the officers and then the 2 breaking off. Given what we've said in Warren, how are we to put that in the calculus, right? That all of the other things in all of the other answers that you've given to some of the other justices' questions, including about the tip, that it wasn't localized to this defendant. What are we to make about the fact that he sees these 2 folks just break away? We don't know why. And there could be all kinds of reasons why they want no interaction with the police. Mm-hmm. How does that, why should that enter the calculus? Or how should we use that in the calculus?
Sure. And if I may clarify, because I do think the record is a little bit confusing with the way Officer Lopes observed the juvenile and her companion. Exhibit 1 and Exhibit 4 of the motion to suppress transcript, or the motion to suppress, show his position on Lawn Street. And he's on Lawn Street perpendicular to Heath Street. The group of officers are, for lack of a better word, to the left down Heath Street. If you're looking at Exhibit 1, that group of officers is going into the apartment complex, crossing Heath Street, entering. As that's happening, the officer sees the juvenile and one companion coming down Heath Street from the right into the direction of Lawn Street. And as the group of officers are crossing Heath further down from where the juvenile and her companion are, they make that sharp turn into the courtyard with the distance of a building between them and the group of police officers. So they make that first sharp turn into the courtyard area. In the courtyard, which is easier to see in Exhibit 4, the aerial view of it, they move down, they move through the courtyard, take a left-hand turn, which is the area to which the group of officers were moving. And as the judge finds in his finding of fact, upon seeing that group of officers or realizing they were there, the juvenile quickly turns back around and where she is intercepted by the officer. So she is with one companion at the time she moves into the courtyard. All of that being said, the manner in which she is moving to avoid contact with the police, we can see does not carry the day here. That is not a overly important fact in the totality of the circumstances for reasonable suspicion. It's hard to separate because her behavior by moving so conspicuously into the courtyard is what the testifying officer notices about her. That's why his attention is drawn to her, because of that initial movement. And beyond that, once she enters that courtyard, it's her continuous, ongoing grabbing of her waistband, turning her body, acting as if to conceal, looking back over her shoulder to ensure she's alone, that draws the officer's attention, and that in his forms reasonable suspicion. Adding to that is the fact that when she and her companion make that left-hand turn, it's only she that comes back. She moves away from her companion. And again, not that her motions, her physical movements to avoid contact with the police carry the day, but they're enmeshed in the conspicuousness of her actions and what her actions indicate to the officer about what is in her waistband, why she's behaving that way, why she wants to be alone, why she's moving so erratically and so confusingly, but not for what she is holding and trying not to drop in her waistband.
Well, Ms. Sherman, I think what's challenging about this case, because you seem to almost be describing a probable cause situation. And what's difficult about this case is if the police officers pull an individual over and the individual is continuously going to their waistband or turning to the side, or there's a shooting and the police approach some people and they continuously are reaching into their waistband or continuously turning to the side, or even periodically, the police are going to have concern. And I think what's hard about this case is that's not this case. This case is hours after information that doesn't add up to very much. They're reaching out and initiating contact with an individual, not to deal with constitutionally justified stop of a motor vehicle or an investigation of a shooting, not even an investigation that people might have firearms because of how stale the issue is. So it's dramatic to say somebody's continuously going to their waistband and turning to the side, but it's sort of in a vacuum of, you just have a bunch of people out and about with no issue that led to a stop.
And in some ways, the context that this is in is actually strong for reasonable suspicion because he is seeing this person from a distance. He's not initiating contact with her. Also, just to clarify, he is watching her from a distance, as is made clear in the record. She has no contact with, close contact with police officers until he stops her. And he is not seeking someone matching her description. There are none of those factors, but what there is his attention being drawn to her because of what all of her behaviors say to him and what all of these taken in totality say to him. And you bring up the probable cause standard, and what is before this officer, him seeing somebody that he believes to be carrying a firearm in her waistband based on several specific and articulable facts. What more would he need for reasonable suspicion? Seeing the butt of the gun, seeing the shape of the gun.
What about DePisa? Is this case weaker than DePisa?
I'm sorry, Your Honor.
DePisa.
Unfortunately, the facts escape me off the top of my head.
On DePisa? Okay.
Yes, I apologize.
All right.
What's the closest case? I understand DePisa is not fresh in your head. What is the closest case that supports your position, in your view? Because Ms. Jellison distinguishes Mata and DePisa. What case do we look at and say, okay, this combination of blading or movement to turn away and continuously reaching into your waist is sufficient?
I think Evelyn is a strong case for that position. Evelyn, the distinction that's very different than the facts here is the fact that it's in the recent aftermath of a shooting. That said, the actions taken.
Doesn't that's Justice Lowy's point, that we're doing this in a vacuum, which is different. I mean, I get it if there's a report of a bunch of kids half hour ago in front of the building playing with a firearm, and then they arrive there and see a bunch of kids together. That seems different, but this is in a vacuum. I'm just trying to get a sense, is there a case like this, just one of these normal street encounters with the police and adults or kids that's like this?
And if I may just address that issue of the vacuum, like you're saying, he's not arriving and there is no factual connection between the phone call and what he observes when he's there in terms of a group of kids indicating that they have a firearm, but it's one person indicating that she has a firearm. And he stops that one person, not the person that she's with, just her. And he stops just her because of the totality of what she's doing.
Again, Ms. Sherman, I'm just looking for an example of a case like this, because I get it when we've got, sort of an APB, there's a fire, shots fired or a firearm identified. We've got to be protective, but this is a little different. I'm just looking for a case where the police are sort of wandering around a neighborhood and this is kind of enough. Is there anything like this out there?
I'd be happy to follow up with the court in a 16L letter. I just want to emphasize, for the risk of being repetitive, that it is just the reasonable suspicion standard here. That's what we're looking at. It's lower than probable cause. It's lower than preponderance.
Ms. Sherman, if I could just interrupt you for a moment. What I think what we're trying to get at is, let's say there was no report of kids with a gun at all, and the police decide to go to a housing development area, and there's a rock there, and they sit on the rock, and they just wait around and start looking to see if anybody's who notices them is reaching into their waistband or turning to the side, and they see somebody that does that. And the question is, could that situation ever rise to the level of reasonable articulable suspicion? Because when you hear about continuously, going to the waistband and turning, and you've got an Evelyn shooting situation, or you have even a situation with a civil motor vehicle infraction, and the police have to approach, 3 occupants at night. Here, what we have is if you discount the firearm, then what we have for an analogous situation is, it's lunchtime and the police decide to, at a particular housing area, to hang out on a rock and have lunch and look around, and then they see somebody going to his or her waist and turning to the side. And that's, I think, what we're looking for, if there's any case along those lines. Perhaps there isn't.
And I will be happy to look into that for the court.